Thanks very much for coming. And thanks to Stanford Law School for inviting me, and I imagine I can speak for all of my fellow panelists to this very interesting program. I was asked to keep introductions short, which I think is a very sensible thing. You guys have all of the details here. Basically, what we can say is that Kent, Steve, and I are law professors. And Nadine is also a law professor, but as well had been for 17 years, am I right on that?
18.
18 years, president of the ACLU. And Eugenie Scott is the executive director of the National Center for Science Education and the author of Evolution versus Creationism, an Introduction, and a co-editor of Not in Our Classrooms, Why Intelligent Design is Wrong for Our Schools. So we have a very a panel very professionally mixed. Only 4/5 law professors. Exactly. So I was asked to moderate, but also to begin by basically summarizing the Edwards case, the Edwards v. Aguilard, and saying a little bit about my thoughts about the case, but then mostly leaving it to the others. So Edwards versus Aguilard. What did it involve? Well, there's a statute that said that if evolution is taught in public schools, creation science must also be taught. And the theories were defined as the scientific evidences, odd usage, but there it is, for creation or evolution and inferences from those scientific evidences. So the theory was this: if you're going to teach evolution, you must teach creation science. If you don't teach evolution, you don't have to teach creation science. And that was, I take it in part, a response to the fact that some 10 years before the statute was passed, the court in Epperson v. Arkansas, a little over 10 years, had said that you can't just ban the teaching of evolution. So they said, we're not banning it, but you have to teach its complement, which defined as creation science, if you teach it. And the Supreme Court then struck it down 7-2. And it struck it down under the purpose test. Now, there is this famous case, Lemon versus Kurtzman, that yielded a much debated, much derided, I think justly derided, but nonetheless quite enduring three-pronged test, the Lemon test. And the Lemon test says that a law can't have a primary purpose to advance religion, primary effect of advancing religion, and it cannot excessively entangle government with religion. Of course, it doesn't explain what any of those terms mean. And the 40 years since Lemon was decided were occupied with attempts to explain that, coupled with arguments that the test as a whole should be entirely jettisoned. This case was focused pretty much exclusively on the first prong of the test. And the majority articulated the test as being whether the government's actual purpose was to endorse or disapprove of religion. And if that was the actual purpose, then that made the law unconstitutional. Note, it's not enough that the backers of the law be motivated by religion. Lots of movements: civil rights movement, temperance movement, abolition movement, anti-war movement, and such. Many of the backers were motivated by religion. That does not invalidate a law. Nor does it matter that the law coincide with the tenets of a particular religion, whether those tenets have to do with alcohol or with civil rights or with sexual morality and such. Lawrence v. Texas, for example, said that bans on same-sex sexual activity are unconstitutional, but it did it on substantive due process grounds, not establishment clause grounds, even though those laws do coincide with the views of some religious groups. So the question here wasn't whether the backers were religious or whether they just had a religious motivation as such. It's whether the actual purpose of the government was to endorse or disapprove of religion. Now, what was the stated purpose of the law? The stated purpose was to promote academic freedom. And the majority said, well, that is a sham. That's not the true purpose. If it were the true purpose, then in that case, that would be constitutional, or at least wouldn't run afoul of the religious purpose prong, but that wasn't the true purpose. The law, the majority said, doesn't advance the freedom of teachers to choose what to teach. It's one understanding of academic freedom that we in universities sometimes use, although not exclusive. Because, after all, teachers could be limited by their supervisors in what they could teach. And in fact, the law itself said you don't have the freedom to choose just one and not the other. It doesn't advance the goal of teaching all the evidence, the court says. It actually serves to diminish academic freedom by removing the flexibility to teach evolution without also teaching creation science, even if the teachers think that the curriculum it becomes less effective and comprehensive in its science instruction. And it fails even to ensure that creation science will be taught, but instead requires the teaching of this theory only when the theory of evolution is taught. Rather, instead of, now that it has said that's not your purpose, has the distinctly different purpose of discrediting evolution by counterbalancing its teaching at every turn with the teaching of creationism. It's a standard way that lawyers do when they're asked to talk about motive. Actually, it turns out that motive is actually very rarely an aspect of a legal rule, sometimes, but rarely. In murder, for example, murder is murder whether or not you have a motive, but it's often factually pretty important, and lawyers often look at motive arguments and say, well, one side says that their motive was this. If that was the motive, then we'd have one legal outcome, but that can't be the motive because look at all the ways in which its actual actions were inconsistent with that motive. Therefore, the real motive was something else, and the something else was to discredit evolution by counterbalancing its teaching with creationism, and therefore to convey a message of endorsement of religious belief. Among other things, the main legislative backer, Bill Keith, whom we'd heard mentioned, had said apparently that he'd rather that neither evolution nor creation science be taught. So he was essentially saying he wanted a world like the world struck down, or the rules struck down in Epperson v. Arkansas. So he seemed to be trying to suppress the teaching of evolution. That's what the majority said. What's more, the majority pointed out the act provides discriminatory preference for teaching of creation science. It's not just even-handed, the majority says. For example, it requires that curriculum guides be developed for creation science, but it says nothing of comparable guides for evolution. It says resource services supplied for creation science, but not for evolution. Only creation scientists, I'm sorry, I mistyped that. Only creation scientists can serve on the panel that supplies the resource services. What's more, the Act forbids school boards to discriminate against creationists, but doesn't protect those who choose to teach evolution or any other non-creation science theory, or who refuse to teach creation science. So it's pointing to all these things, trying to identify what the legislative purpose was. So the legislative purpose was, in fact, suppressing the teaching of evolution or promoting the teaching of creation science as a means to the end of disapproving of, of endorsing religion and disapproving of scientific views. What's more, the court said, look, we have to look at the historical background. There's a historical and contemporaneous link between the teaching of certain religious denominations and the teaching of evolution. Then the preeminent purpose of the legislature was clearly to advance the religious viewpoint that a supernatural being created humankind. The court pointed out that because the focus is on purpose, you could have, under other circumstances, perhaps even similar rules that would be constitutional if they had a good purpose. But this rule did not. So teaching a variety of scientific theories about the origins of humankind to school children might be validly done with a clear secular intent of enhancing the effectiveness of science instruction, but here that wasn't the intent. Rather, the primary purpose was to endorse a particular religious doctrine. So that's the majority. The majority was 7 justices. 2 justices, Powell and O'Connor, had a concurrence, and one of the justices actually Justice White had a concurrence in the judgment, so technically you might say it's 6-1-2, but for our purposes, we'll treat the Powell, O'Connor, and White positions as similar enough to the majorities. The dissent was Justice Scalia, joined by Chief Justice Rehnquist. And the dissent did 2 things. One is it said, look, there are other possible purposes that might be in play, and the majority is not really doing justice to this. And the other thing that the dissent said is, in part based on this evidence and of how hard it is to figure out the purpose, that the whole purpose prong is unsound. And whatever the Establishment Clause inquiry should be, it should not be about the legislative purpose. So first, the dissent points out that if we're asking about purpose, what matters isn't whether the legislators were right in particular judgments, but whether they were sincere. So for example, if the legislature sincerely believes that the state science teachers were being hostile to religion, and that the Establishment Clause requires elimination of that hostility, and the court has at times said that hostility to religion is just as unconstitutional when it comes from the government as endorsement of religion, then that would be a permissible secular purpose, at least a permissible purpose. You may label it secular or not, but a permissible purpose to try to alleviate this constitutional violation. Now, maybe the legislators were wrong in thinking the state science teachers were being hostile to religion. Maybe they were misinformed. Maybe they misunderstood the commands of the Establishment Clause. But if that was their sincere purpose, then if you're looking at the purpose, that the dissent says that would be constitutional. Or they might have believed free exercise clause required accommodation of creationist students. We heard some hint of that argument that had been made earlier today, or rather, earlier today we heard about how this argument had been made. But the basic principle is, if the legislators thought that religious freedom required that students not be put in a position where they're forced to go into schools that are deriding their views or that they perceive as teaching things that are hostile to their views, then in that case, the legislators would again be free from a purpose perspective to try to accommodate the students, even if it turns out they misunderstood the commands of the Free Exercise Clause. Likewise, they might have believed that accommodating such students was permissible, even if Free Exercise Clause didn't require this. They might have said, look, the fact is there are all these students that have these views. We want to accommodate them. We don't want them to feel that they're learning in this environment that's hostile to their religions. And therefore, that's something that we ought to be doing. And again, if that were their sincere view, that, Justice Scalia says, would be constitutionally permissible. But there are other purposes. For example, maybe they actually, the legislators actually believed that creation science was good science. Perhaps they were flat wrong. I have no reason to think, by the way, that Justice Scalia is a creationist. He's a pretty devout Catholic, and as I understand it, Catholicism, at least for modern Catholicism, is quite reconciled to evolution. But he says, look, let's say they believe this. Rightly or wrongly, they believe this. And they, therefore, want creation science to be taught because they think it's accurate, and their purpose is to teach students accurate things. Again, from a purpose perspective, the dissent says that's a permissible purpose. Or they might have supported academic freedom, not in the sense of the freedom of teachers, but the freedom of students from indoctrination. So returning to what Patricia Bowers mentioned in the last panel, maybe they thought that what was important is for students to be able to hear all the views and make up their own minds on this issue. And that Justice Scalia argued that, in fact, there was evidence that that is how academic freedom was understood. Or maybe they thought teaching only evolution unconstitutionally established a religion of secular humanism. Now, we hear a lot of people on the religious right talking about how government action establishes a religion of secular humanism. But actually, the notion of secular humanism as a religion actually comes from a Supreme Court opinion 50 years ago, where the court, in a decision that's generally seen as quite pro-separationist, said, well, there are many religions in a country. One of them is secular humanism. So taking the court at its word, maybe the legislators thought that teaching evolution and evolution alone was an impermissible establishment of that religion. Likewise, as to the supposed discrimination against evolution and for creationism as to things like study guides and such, maybe they thought that special study guides were needed for creationism because establishment science wasn't producing them. There are, in fact, lots of study guides, I'm sure, for evolution. I take it there are a lot fewer for creationism, so perhaps that was a legislative motive. The dissent goes on to make other arguments that actually, though, go beyond this. And they say, look, legislators have lots of motives. Some motives are policy, such as the ones we identified. Some of them are political. Maybe a legislator was a close friend of the bill's sponsor. Maybe the legislator was pressured to vote for a bill by constituents. Maybe he was seeking good publicity. Maybe he thought the bill would provide jobs for his district. There are other things that the dissent didn't talk about, but here I'm going to use my prerogative as speaker as well as moderator to bring a few up. And I should tell you, by the way, I am not at all a creationist. I'm quite irreligious. Lots of very smart scientists think evolution is right, and smart scientists have been wrong, but they are the way the smart money bets, in my view. So I have nothing against evolution and nothing in favor of creation science. But if I were a member of a school board or a legislator in an area where there are lots of creationists, I might say, well, maybe doing this would stem flight from public schools. Maybe there are all of these students, perhaps, in some places there are, some places there aren't, who are leaving public schools because they feel the public schools are hostile to their religious beliefs. Either they themselves choose this or more likely their parents choose this. Maybe it would decrease student alienation from school. Maybe they're sticking in school because they can't afford to go elsewhere, but they think, my God, these are a bunch of teachers whom we don't connect with, don't respect, because they are teaching the stuff that we think is against our religion. Maybe by going halfway to meet them, they will come halfway at being more open to what they're learning. Maybe it'll increase public support for school taxes. You know, taxpayers are not known in many places to be terribly generous in providing more funding for schools. I take it they're probably somewhat less generous when they feel alienated from the schools. They feel their schools are a part of this irreligious establishment that's contrary to their own views. Maybe it would increase public volunteering in schools or public charitable contributions to schools. And many schools now do supplement their funds through that. Maybe it'll just even diminish public hostility along religious lines. Maybe I'll say, you know, I've had enough of this constant debate in which people are saying creationism is being undermined by or the Bible is being undermined by the schools. I feel that it will be just a calmer, more peaceful environment in my state if we had this kind of compromise. Now again, to be sure, all of these claims might actually be false. But the question is, what happens if that is what the legislators actually sincerely believe? Now, there are a couple of possible answers. You might say, well, even if they sincerely believe all of these things, these are still religious purposes. So maybe as a matter of law, even if your purpose is to increase public support for school taxes, if you're doing that by throwing a sock to a particular religious group as to teaching the things that fit their religion, that is still an impermissible religious purpose. But then you'd have to be able to explain what it means to have an impermissible purpose of endorsing religion, because read literally, these purposes may be not to endorse religion. In fact, these purposes could be held by atheists who just happen to think, okay, fine, I'm an atheist, but I'm an atheist in a state where there are enough creationists that I feel I need to have them on board the public school project. Alternatively, you might say, well, as a matter of law, those purposes, if they are in fact the actual purpose, would make the law constitutional. But in fact, those weren't really the actual purposes. And then the question is how you figure it out, especially since many legislators may have all of these purposes together. So somebody who actually believes in creationism, because as a factual matter, may also want to advance its teaching for religious purposes, and may on top of that be very conscious of the fact that the failure to teach, or of his view that the failure to teach creationism is actually causing difficulties for the schools. And the last thing that makes it extra complicated is how is one to determine the intention of a group of legislators, many of whom never speak on the floor of the legislature, many who do speak only ambiguously. We may know, we may be able, or we may at least be able to guess what Senator Keith believes and what Senator Keith wants to do, but what about all of the other legislators, some of whom might, in fact, have been good Louisiana Catholics whose religion does not push them towards creationism, but who said, look, we want to set things up. Either we want to have better relations with our fellow legislators, or we want the schools to have better relations with creationist parents, students, and taxpayers. So the worry that I have in these situations is when you're asking what the purpose, when a court says what the purpose of the legislature is, it may often have more to do with what's in the mind of the justices than what is actually in the mind of the legislators. So with that, I turn to Eugenia.
And for that, I take off my shawl, which kindly was loaned to me by Nadine because it's freezing to death up here. And we will have a slight change of, let's see if something magical happens here. Something magical happened, very good. I'm going to talk about why Edwards is important and what has happened since Edwards. Now, I work for the National Center for Science Education. This organization was founded in the early 1980s by scientists and educators in response to equal time laws at about the same time as the filing of the bill that became the issue in Edwards versus Aguilard. And just as it took time for the Edwards decision to make its way through the courts, it took a while for NCSE to get funding and open a national office. We opened the national office in January of 1987, and Edwards was decided the following June. Edwards has been an extraordinarily important case for NCSE and for others concerned about the teaching of evolution and about church and state separation. One might contend that this decision crystallized the approach of the anti-evolution movement from 1987 until the present, and likely into the near future. Let me explain why I think this is true. As we've just heard, Edwards struck down equal time for the teaching of creation science as unconstitutional. The court ruled that because creation science was a religious view, to advocate it in the public schools would violate the Establishment Clause. Now, creationists were not surprised by this because the McLean decision of 1981, which was one of the topics of the earlier session, had come to the same decision. McLean consisted of a full trial where both the scientific validity of creation science as well as its religiousness were evaluated. So creationists weren't surprised, but they certainly were disappointed in Edwards. Creationists are nothing if not hopeful, however, and they took hope from two elements of the Edwards decision. Justice Brennan had written that teaching a variety of scientific theories about humankind to school children might be validly done with a clear secular intent of enhancing the effectiveness of science instruction. Note that the teaching has to be of scientific theories, not religious views. And by the way, theories is not a word that applies to religious views. Theories is a term of art within science, just like person is a term of art within law. And General Motors is a person, and a developing fetus is not a person, even though that doesn't work in terms of how we use these terms in the public. Similarly, theory in science is an inferential explanation. It is not a guess or a hunch. So when we talk about a scientific theory, that's really quite different from a religious position. Note also that there has to be secular intent. And this, of course, follows the prescriptions of Lemon. The people, and Justice Scalia had a dissent, which we've heard a lot about, in which he wrote, "The people of Louisiana, including those who are Christian fundamentalists, are quite entitled, as a secular matter, to have whatever scientific evidence there may be against evolution presented in the schools, just as Mr. Scopes was entitled to present whatever scientific evidence there was for it." Now, Justice Scalia used the Edwards decision to attack the Lemon decision, which he hates. But it's very interesting when I talk to lawyers, they all say, oh yeah, Lemon, we don't like Lemon very much. We don't like the three prongs of Lemon. But when it comes to creation and evolution cases, it is always just right on target. Of all the Establishment Clause cases you might apply Lemon to, where it really works, and maybe the only place it really, really works, are in these creationist issues. So the loopholes that creationists found was, of course, the Brennan decision, in which Brennan mentioned in sort of an aside that it was perfectly fine to teach scientific alternatives to evolution. And of course, that's true. If there were any scientific secular alternatives to evolution, it would be perfectly reasonable to teach them. There are no secular scientific alternatives to evolution. Recall that the original scientific alternative to evolution was creation science. And shortly after Edwards, a modified form of creation science called intelligent design began to be popularized. It was a stripped-down form of creation science, leaving out the fact claims that had proven fatal to creation science during McLean, and which frankly had never appealed to the bulk of American Christians. Catholics and mainstream Protestants looked askance at a six-day creation 6,000 years ago, to say nothing of Grand Canyon being cut by Noah's flood. The small school district of Dover, Pennsylvania would be the test case for the legality of the teaching of intelligent design. The district had struggled with the teaching of evolution for several years, with many conservative school board members trying various strategies to balance evolution with some form of creationism. To make a long story very short, after much wrangling, a policy requiring the teaching of ID was passed. A group of parents sued, and the judge ruled against the district, declaring ID to be not only a religious idea, but one without any valid secular purpose for its teaching. In this case, in this sense, the Kitzmiller versus Dover case was very similar to McLean versus Arkansas. NCSE advised the plaintiff's legal team on issues of science, education, and the history of the creationist movement. The Edwards decision essentially dictated our case. That plus, of course, standard Establishment Clause case law like the prongs of Lemon and the endorsement test, The defense's job, the other side, was using Lemon to demonstrate that there was a secular purpose and effect of the Dover policy. This meant that they had to show that ID was valid science, therefore there was a secular pedagogical purpose for teaching it. They also wanted to show that evolution was questionable because part of the Dover policy called for the teaching of the, quote, gaps/problems in evolution. On the plaintiff's side, our side, they had to refute these positions. Specifically, because of Edwards, we wanted to show that ID was really renamed creation science, which the Supreme Court had already struck down. Game over. But just to be sure, we wanted to have plenty of ammo that to hammer down the idea that there was no valid secular purpose for teaching ID, that intelligent design was not science, that the few fact claims that it did make were factually wrong, and therefore, because of the gaps problems in teaching evolution issue, we also had to demonstrate that evolution was solid science. If it didn't follow the precepts of science and it was factually wrong, it would be hard to argue there was much of a secular purpose for teaching it. This cartoon from the New Yorker sort of sums it up pretty well. So certainly the Edwards decision was important in the first test of the constitutionality of teaching ID, and doubtless it will be in the next one as well, since like McLean, Kitzmiller versus Dover was not appealed and remains precedent only in the Middle District of Pennsylvania. Let me move on to the second loophole from Edwards, and this comes from Scalia's dissent proposing that it was just fine for teachers to teach the, quote, evidence against evolution. Immediately after Edwards, the Institute for Creation Research jumped on this idea from the dissent and proposed that teachers should teach the evidence against evolution. Now notice the last line of this paragraph. Because evidence against evolution is evidence for creationism. This is a long-standing meme of creation science. What Judge Overton said in McLean was a contrived dualism. They call it the two-model approach. They believe that their version of biblical special creationism is a dichotomous choice with evolution. Hence, disproving evolution is sufficient to prove creationism, if not A, then B. It also has the advantage that in their belief, if a student hears that evolution is bad or weak science, he or she will automatically conclude that God therefore specially created. And they are probably right. I think this is pretty much what students do. They think the same dichotomous way that creationists do. Now, during the 1990s, there were a series of cases where teachers attempted to teach alternatives to evolution and or evidence against evolution. Their districts told them to stop. The teachers sued their districts and lost. You have to realize, those of you who are not lawyers, that a K-12 teacher has very little academic freedom to diverge from the district's curriculum. Courts have long held that a district has an interest in continuity from classroom to classroom. Therefore, a K-12 teacher has very little academic freedom. If you sign a contract to teach in a district, you have agreed to teach the curriculum for that district. Now, all of these cases cited Edwards, mostly they leaned on employment law, the right of the district to restrict the teacher's content. Now, creationists realize that top-down approaches fail. Equal time laws like Arkansas and Louisiana failed. The court struck them down. District policies such as Dover get knocked down by the courts as well. Approaching the issue of the teaching of creationism, we're balancing evolution somehow by allowing individual teachers to freelance, shall we say, might be more fruitful. Certainly there are many teachers who are sympathetic to teaching creation science. Survey research suggests 25 to 30% perhaps. But cases like Webster, Pelosa, and LeVake were frustrating to creationists, showing that teachers were not going to be allowed to freelance the teaching of creationism. This is not a change of subject. Senator Rick Santorum of Pennsylvania proposed a Senate resolution to the No Child Left Behind Education Bill of 2001 that after modifications ended up in the conference committee report. It called for teaching the full range of scientific views, which sounds benign until you realize that creationists believe that creation science and ID are scientific views. The original amendment was written by the University of California law professor Philip Johnson, one of the driving forces behind intelligent design. His purpose was protective, to avoid the problems of Levesque, Pelosa, and Webster, who had been disciplined by their districts for the teaching of creation science or evidence against evolution. Shortly after the passage of the No Child Left Behind bill, many states had legislation introduced that used the full range of views language found in the Santorum Amendment. This is only a sample from a couple of years. We have lots more. Paralleling and influenced by this approach, in 2004, the first Academic Freedom Act was introduced in Alabama. The Academic Freedom Act in Alabama was intended to provide protection to teachers who want to teach alternative theories. The sponsor said, quote, "This bill will level the playing field because it allows a teacher to bring forward the biblical creation story of humankind." See what I mean about these cases really being absolutely on point for the purpose prong of the lemon? And case after case after case, loose lips sink ships. They're being more careful about what they say to the press now. Later versions of the Alabama law from 2005 onward included the Santorum full range of scientific views language. Let me just summarize because we don't have very much time to talk about the Academic Freedom Acts, but they're very, very clever. They avoid religion, they avoid any mention of creationism, anything that could be construed as a religious component, obviously trying to avoid the Establishment Clause. They stress free speech. They stress academic freedom. They stress critical thinking, all of these being very popular ideas in the American public. I'm all for critical thinking. Raise your hand if you're against critical thinking. Nobody's going to, everybody's for that. They tend to be protective bills, giving a teacher license to teach alternatives to evolution or evidence against evolution. They've been described by me and others as a get-out-of-jail-free card for a creationist teacher. We'll see if that actually is the case when these bills are eventually litigated. They are permissive bills, which is another very clever approach. Rather than being a thou shalt go forth and teach creation science, intelligent design, whatever, these bills say teachers may do this, which makes it, of course, extremely more difficult to get a TRO, the temporary restraining order for non-lawyers like me. It makes it extremely difficult to make a facial challenge. You have to wait for an applied challenge, which of course raises the bar considerably higher for finding a plaintiff with standing, etc. So these bills are very cleverly written. They also often avoid singling out evolution by embedding evolution with other controversial issues, which of course are not controversial scientifically, things like global warming, stem cells, human cloning, etc. But they are views that are controversial in terms of the interests of the religious right. Over the last several years, since 2004, there have been about 40 of these academic freedom bills proposed in legislatures around the country. Only 2 of them have passed, Louisiana in 2008, and this year Tennessee in 2012. This is a phylogeny of academic freedom acts. There are 2 main trees with some horizontal gene transfer between them, if you will. Apologies for not having time to bring this illustration up to date. It ends in 2009, but trust me, the academic freedom bills have not. The original Alabama bill proposed legal protection to students and teachers and proposed the teaching of alternative theories. The Discovery Institute critiqued the bill, and later versions of the Alabama bill dropped references to alternative theories because alternative theories is obviously a dog whistle to creationists. Instead, these bills replaced the alternative theories language with the Santorum full range of scientific views language. The Discovery Institute's own model bill refers directly to Edwards versus Aguilard, talks about scientific critiques of prevailing scientific theories could be taught, and strengthens the Santorum language. The other strain of academic freedom acts originated from a 2006 policy passed by the Ouachita Parish, Louisiana School Board, promoted by the Louisiana Family Forum. It is couched in terms of encouraging critical thinking of students, the critical analysis of scientific theories. The Louisiana Academic Freedom Act, passed a couple of years later, introduced by the father of the Ouachita Parish bill, added the provision that administrators cannot censor materials and included a disclaimer that this bill was not intended to promote religion. The two strains, as in horizontal gene transfer, have influenced one another. The left talks about the full range of scientific views language from Santorum, but also encourages students to attack the validity of evolution arising from the Scalia evidence against evolution language. On the right, you have more directly the evidence against evolution language, strengths and weaknesses, critical analysis, and the like. This strain also often includes global warming, stem cells, human cloning as similar controversial issues. The Tennessee bill that passed in 2012 was an example of this cross-fertilization. It included global warming and the other bundled controversial issues, but primarily was modeled on the Louisiana bill. Schematically, we have the following. Creation science begat intelligent design, and in the post-Edwards versus Aguilard period, we have two branches. One, the evidence against evolution branch, the Scalia dissent. The second, the alternative theories branch, the Brennan decision. If you ask the proponents of alternative theories, where will we find them? Because we can't find them within the scientist literature, they will refer you back to intelligent design and creation science. If you ask proponents of teaching evidence against evolution, where will I find the list of evidences against evolution? An interesting story behind that. They will refer you back to intelligent design and creation science. So basically, these are ways of sneaking intelligent design and creation science back into the curriculum, but avoiding the more overtly religious wording. The history of this controversy has been to somehow balance evolution with something. With creation science, well, Edwards took care of that. No longer is it possible to legally balance evolution with creation science. Balance evolution with intelligent design, well, the Kitzmiller decision hopefully stopped that. Now we have a third approach, the evidence against evolution derived directly from Edwards. Whether that will be legal or not has not been tested by the courts. More information on this can be found at ncsc.com, which is NCSC's website. And I want to thank my colleague Glenn Branch for noticing that this is the 25th anniversary of Edwards versus Aguilard, and suggesting to Ed Larson and the good folks at Stanford that this would be a very good topic for us to talk about. And I thank him for thinking of it, and I thank the Stanford people for having this most interesting topic.
Well, I'm delighted to be here. It's a very interesting topic. So I'm going to talk about things that I think are left unsettled by the Edwards versus Aguilard case in the relations of science to intelligent design, and more broadly what the coverage of religion should be appropriately in public schools. I'm going to take these in turn, and I'm going to try to do it briefly, hoping that that will lead to some time for discussion. I'm not an expert on much that I'm going to say, but I did try to think about this pretty hard and concentrated on it some years ago in my writing. So I start with two premises. One is that public schools shouldn't teach that any particular religious convictions are true, and this, of course, is settled by the Supreme Court. And that secondly, they shouldn't decline to teach a topic that would otherwise be obviously called for in a course because it offends religious convictions of some people. Epperson versus Arkansas stands for that. That sort of leaves open whether if you've got some borderline something that could be in a course or not, whether if people don't like it on religion, whether it's okay to drop it out for that reason. Okay, turning to evolution and intelligent design. Evolution, what now might be referred to as neo-Darwinian evolution, is obviously a central aspect of biology. I think this is right. It would obviously be taught if one only asks about its importance for the subject. Thus, a refusal to teach it on religious grounds is impermissible. Now, what do we mean by creationism and intelligent design? And the discussion, Professor Numbers showed the variations on that. So if we're thinking about creationism as the idea that the Earth was created about 6,000 years ago and that no evolution has occurred from one species to another, well, the first premise is just at odds with various branches of science, including astronomy, geology, paleontology, and biology. And I think there's really no real scientific support for the second premise. So at least if religious views seem to be the causal explanation for why this would happen. It would be unconstitutional to teach as science what lacks virtually any scientific evidence. This assumes that science is based on a kind of methodological naturalism. So I think the result in Edwards is correct, even if the legislators were somehow themselves persuaded that this was scientifically plausible. Now, but if we turn to the most modest versions of intelligent design, of which I'll mention really two, one is that design could be behind evolution and sustain it, that God might be sustaining this, or that it could explain certain gaps that evolution can't now convincingly explain. And then relatedly is the question, what should science courses teach about the limits of science? And I think this is actually the crucial question, not what counts as science here, but what should be taught about the limits of science. So these are some limits as I see them. One, science can't tell us why there's anything at all. It can start with something and have a big bang and everything from that, but why is there anything? I don't think science can tell us that, and I think that is something that occurs to me from time to time, especially as I get older. It can't rule out the possibility that there's some higher guidance under the rules of science, although it could suggest that God can't be perfect and completely well-intentioned if evolution occurs in certain ways. It cannot rule out the possibility that some things occur that can't be explained by science, and are actually, some of them, contrary to the settled laws of science. Now, that is true, of course, about claims of miracles, as an example. And I think it's interesting for those who are not Catholic, and I'm not Catholic, how carefully the Catholic Church really tries to get into whether the claimed miracles could possibly be explained naturally. And of course, it may be a presupposition of science that nothing could occur in this way, but science itself can't show that. And finally, it can't establish that if the conclusions of science conflict directly with some religious premise, that really science tells us what actually happened. Because of course, it's always possible that God led us to think ways that are contrary to what actually is going on in God's universe. I mean, I think that's very implausible, but it's a possibility. Now, I think, at least before I wrote these notes, that ideally science courses should mention these limits, but I don't think they're constitutionally compelled to do that. Now, I was taken aback a little bit by Michael's suggestion that if you add qualifications, it's not good for students. But I really, I don't know about that, but I think ideally thinking about what's appropriate, it seems to me that there's some indication of what the limits of science would be appropriate in science courses. Now, intelligent design in its most modest form is, as according to my account, is consistent with what science courses should teach. But I think, again, it's really about the limits of science rather than itself a scientific theory. That's number one. And number two, it should not be presented as the alternative to a full evolutionary theory, because if evolution has a hard time now explaining certain developments, evolutionary theory may develop later on and be able to explain them, or there may be some other scientific theory that explain it. It can't be that intelligent design is really the only alternative explanation. So I don't think it could be presented as the alternative explanation in a science course. Okay, having said that, I'm going to say something a little bit about teaching about religion more generally. It's clearly acceptable to teach about religion if no position is taken on what is religious truth. This is in public schools. Now, that clearly belongs in courses about history, literature, studies of music and art, where you'd certainly not want to exclude all religious music and art, and a course on comparative religion. I think in comparative religion, if you tried to do such a course for high school students, which I think would be appropriate, it of course is tricky as to how you would allocate time among the various religions. How much would you emphasize the ones that are really taken most seriously here as opposed to worldwide and so on. Now, I think more debatably, his course is about moral education, but I think it would be appropriate to present religious perspectives about that, because many people, including certainly adults, and I think appropriately for children, might think that some moral questions are best approached or partly approached from religious perspectives. So I think that it would be appropriate to include that. And I think yet more debatably in courses about economics, that there are religious views about economic distribution that might diverge from the idea that efficiency or utilitarian maximization is what we really should be aiming for. So I think if you don't say anything about religious views, which I think would certainly be the approach in 99% of economics courses, that would understate the present influence and possible relevance for the future of religious perspectives on these normative questions. So I think there's lots of room for teaching about religion in schools as long as no assertions of religious truth are made. Now, is this constitutionally compelled? Now, religion is an important possibility for many people deciding how to live. Certainly, most people in this country say they're religious. How often, for how many people it's really important to how they live, I'm not sure, but certainly a significant number. There's certainly a plausible argument that if you disregard religion, even if this is not what you're trying to do, that the effect is to be antagonistic to religion, to downplay it. And you can make a claim that this violates the Establishment Clause by establishing, a kind of atheism or disregard of religion. Now, Warren Nord, in a book, Does God Make a Difference, published after he died, regrettably, charged that the present practice actually violates the idea of neutrality and violates the Constitution. And the promotion of religion in public schools, of course, Charles Haynes has been a prominent figure in that as well. Now, I think, and I say this in a very brief review of the Nord book, that I think that while I think there's a lot to what he says, I don't think that he's right that there's a constitutional violation if you disregard religion, and these are my reasons. One, I think you need a more direct intentional violation of neutrality in order to amount to a violation. A lot of teachers would be incompetent to teach religion in a kind of neutral way that takes adequate account of the different religious views and presents them. I don't think we have very many teachers that are actually prepared to do that. It's very hard to review the exact permissible range of what the teachers could say and not say about particular religions as to whether they would seem to be promoting their religion or putting down some other religion. And many people may prefer just to have religion left to families and churches and so on, and really don't want it presented neutrally in public schools. Now, I think for all these reasons, that if school boards or higher up school authorities decide that it's better to not pay very much attention to religion, that's not unconstitutional. But I do think it's a question how much religion there should be taught in public schools, and I think ideally it would be a good bit more than we have now in the vast majority. Thank you. Nadine?
Great. Well, many thanks to the conference organizers and participants. I'm really having even a much better time than I thought I would. So I recently ran into somebody that I hadn't seen in 25 years, and he asked me what I'm working on now, and I realized how many current issues now are the very same ones on which I had been working 25 years ago, including this one, but it's not the only one. And that would have been no surprise to Roger Baldwin, who was the ACLU's principal founder and the instigator of the Scopes case. Roger often observed, no fight for civil liberties ever stays won, and that certainly has been true for our string of fights and wins on the intellectual freedom issues surrounding evolution, including Edwards versus Aguilard, and more recently, the 2005 lower court victory from the intelligent design case in Dover, which Jeannie described. And now we're monitoring the implementation of the latest version of these laws enacted in Tennessee in February and Louisiana in 2008. The type of so-called balanced treatment law that Edwards struck down was first passed by Arkansas in 1981. At that point, Roger Baldwin was only 5 months away from the end of a very long life, but he was not at all running out of impassioned activism, so he immediately phoned his then successor as ACLU executive director, Ira Glasser, and he demanded, "What are you doing about it?" Well, no sooner had the ACLU and our allies succeeded in striking down the Arkansas law in 1982 than we were already battling the slightly more subtle version of the same law in Louisiana. 5 years later, when the Supreme Court handed us the Edwards victory, a reporter asked Ira Glasser, "How long have you been fighting this case?" To which Glasser replied, 62 years. And now it's 62 plus 25. So in reflecting on the issues implicated by Edwards, especially in light of the current anti-evolution laws that Jeannie described, which overtly target other topics, most prominently global warming and cloning, given that broader terrain of these current laws, I want to focus on a broader rationale for challenging these kinds of laws beyond the specific Establishment Clause rationale. Now, as Eugene so cogently explained, the Supreme Court struck down the law in Edwards on the ground that it lacked a sufficient secular purpose. And interestingly enough, that's the very same rationale that the court had previously invoked for invalidating Arkansas's outright ban on teaching evolution in 1968 in Epperson versus Arkansas. And that specific rationale is noteworthy because, as Eugene indicated, the Supreme Court has only extremely rarely struck down a law, including under the three-prong Lemon test. One of those three prongs is the secular purpose requirement, but the Supreme Court has actually based very few of its holdings that a law violates the Establishment Clause on the finding that it lacked a sufficient secular purpose. And that whole prong has been very strongly challenged by Justice Scalia. Interestingly enough, he had only one vote for his argument in Edwards that the whole prong should be invalidated, but in the most recent case that raised this rationale, happened to be another ACLU case on another topic, the posting of the Ten Commandments in a government building. Justice Souter wrote the majority opinion also basing the holding on lack of adequate secular purpose, and that prompted Scalia, this time with 3 justices supporting his position, that the whole secular purpose prong is invalid and no law should ever be struck down on that basis. Since then, Justice O'Connor, who was in the majority in the Ten Commandments case, has of course retired, been replaced by Justice Alito. So I think there's a good chance that this whole rationale, which has been the underpinning for both of the evolution cases, is just going to be out the window. And we're going to have to find those of us who think that there is some constitutional problem here are going to have to find another theory in the legal sense of the word theory. That said, in my remaining time, I'd like to move beyond the Establishment Clause altogether to outline a broader First Amendment framework for challenging any measures that constrict intellectual freedom in the classroom, not only anti-evolution laws and not only laws that reflect a religious purpose. And I think that it's important that we have a broader First Amendment framework, especially because the current laws are couched beyond just attacking evolution, but other scientific subjects as well. So my contention is that the First Amendment's free speech clause should invalidate any curricular measure whose purpose is to limit the discussion of any topic or idea due to any ideological disagreement. The Supreme Court's case law directly on point is very sparse. Nonetheless, the court's limited pertinent discussions do support the broader right I'm advocating. But before I amplify on that right, I want to stress that it was this broader intellectual freedom right that the ACLU advocated way back in the Scopes case and in fact, even earlier. In preparing for the conference, I had the pleasure of rereading Ed Larson's magnificent book about the Scopes case, which stressed this point. Ed describes the ACLU's pre-Scopes campaigns against restrictions on teaching various unpopular ideas, including in the secondary schools, dating back to the ACLU's founding during World War I. For example, the ACLU challenged laws that barred teaching subjects ranging from German to pacifism to radical political ideas. And in rereading Ed's book, I was also reminded of a connection between the evolution controversy as well as the larger academic freedom issue that it exemplified at our conference venue, namely that a leading figure in these debates was Stanford's then president emeritus, David Starr Jordan. Ed notes that even before the Scopes case, the ACLU had formed an elite committee on academic freedom, which included Jordan. Moreover, after initiating the Scopes case, the ACLU invited 20 prominent progressive educators to serve on an advisory committee to help raise money for the defense. All 20 accepted the invitation, including the two whom Ed called the two senior statesmen of American education, Presidents Emeriti, Eliot of Harvard and Jordan of Stanford. Although the Supreme Court's decisions in Edwards and Epperson, the two evolution cases, were based solely on Establishment Clause concerns, Justice Stewart's Epperson concurrence expressly invoked the broader Free Speech Clause rationale. Now, his conclusion was that Arkansas's ban on teaching evolution should be struck down on vagueness grounds, but he noted that at least one of the plausible meanings of that law, namely to completely forbid any discussion of evolution, he concluded that, quote, would clearly impinge upon the guarantees of free communication contained in the First Amendment. The court as a whole has issued only one decision that directly discusses curricular restrictions that do not clearly implicate religion, and that discussion was only in dicta. It wasn't necessary to decide the case, and it was in a plurality opinion, got only 4 votes. That was in a 1982 case called Pico, yet another ACLU case, I'm proud to say. So the court hasn't expressly laid out a general First Amendment framework for protecting intellectual freedom against curricular restrictions that do not have a religious purpose or a religious effect, but Pico and other rulings that bear indirectly on this issue do support the conclusion that the court should strike down curricular measures that have the purpose or effect of suppressing any subject on ideological grounds. Pico specifically concerned a school board's decision to remove certain books from the school library at the behest of a community group on the grounds, I'm quoting the community group, that these books were anti-American, anti-Christian, anti-Semitic, and just plain filthy. Pico recognized that the First Amendment guarantees students some right of access to diverse ideas in public schools. It fleshed out that right only concerning the facts at issue in the case, the removal of library books. It laid out the standard for determining if such a removal violates the First Amendment and remanded the case so the lower court could assess the particular removal under that standard. Now, specifically, the court said that school officials may not remove library books for the purpose of denying students access to ideas with which the officials disagreed. In contrast, the court said if the books were removed because educators deemed them to be educationally unsuitable, that would not carry the danger of an official suppression of ideas. Now, notably, the linchpin of the Pico decision is the very same purpose linchpin for both of the court's evolution rulings under the Establishment Clause. All 3 of these decisions stress in common that government may not choose which materials public school students may or may not access because of disagreement, ideological or religious disagreement with particular ideas. So in the evolution cases, the disagreement, of course, reflected religious beliefs, but Pico recognized that even if the disagreement reflects non-religious beliefs, it would still be an illegitimate basis for curbing students' access to the materials. Of course, the particular measure, now this is for the lawyers because we know the case to some extent can be limited to the particular facts. So the particular measure at issue in Pico is distinguishable from curricular measures. And in dicta, I have to acknowledge the Pico plurality said that school officials might well defend their claim of absolute discretion in matters of curriculum by reliance upon their duty to inculcate community values. And this harks back to one of the points that Mike made in his terrific opening précis, the extent to which school boards epitomize grassroots democracy, where the majority can determine a curriculum specifically for purposes of inculcating certain shared values. In contrast, Pico rejected this claim in the library context because they stressed there the student's choice of books is voluntary. But to my mind, that factor cuts exactly the opposite way. And interestingly enough, the Pico dissenters also stressed that very point. There were two dissenting opinions. They both made that point. Then Chief Justice Berger, writing for the four dissenters, said, required reading and textbooks have a greater likelihood of imposing a pall of orthodoxy over the educational process than does optional reading. And there are many reasons why you can argue that the intellectual freedom of students is especially vulnerable in the classroom setting regarding curricular decisions. They're required to attend school by compulsory education laws. They're required to read books that are assigned as part of the curriculum. That makes them what lawyers call a captive audience, whose First Amendment rights are particularly due more protection. As the court has repeatedly stressed, including in the two evolution cases, public school students are young and relatively impressionable, subject to the influence of authority figures such as teachers, given the hierarchical and authoritarian public school structure. So for all of those reasons, they're more likely to be influenced by a teacher's actual or implied approval of certain beliefs, and therefore a teacher's assignment or non-assignment of particular materials in the curriculum may well lead a student to infer that the teacher approves or disapproves of their contents, and that has a potentially coercive impact on the student's own formation of his or her own ideas. Now, of course, teachers can and should take steps to dispel any such potentially coercive impact. I think all of us, no matter what the curriculum is, can and should strive to teach in a manner that's non-indoctrinating. We should always encourage discussion, debate, dissent, critical thinking. We don't need a law to tell us to do that. That's good pedagogy. But the courts should recognize the significant risk of indoctrination or suppression of ideas in the classroom setting, and therefore enforce First Amendment principles to counter that risk. And that is precisely what the court has done when it comes to religious ideas in Edwards and Epperson. So my recommended approach about taking that rationale and extending it beyond the specifically religious domain, that follows not only from Pico, slim pickings as it is, but also from fundamental First Amendment principles that the court has recognized in other cases involving public schools. And again, the other cases involve different factual issues, not curricular restrictions, but these cases have endorsed principles that I think should be enforced at least as strongly in the curricular context as in the other factual settings. Yes, the court has repeatedly recognized that state and local school officials have broad discretion over curricular matters, but every time it recognizes that, it also repeatedly cautions that this discretion, I'm going to quote a phrase that appears in these cases over and over again, this discretion must be exercised in a manner that comports with the transcendent imperatives of the First Amendment. And in that vein, I'd like to end by quoting what I consider the court's most ringing endorsement of freedom of conscience in any case, in any context, and significantly, that case happened to involve students in public schools. I'm referring to the court's eloquent 1943 opinion in West Virginia Board of Education versus Barnett, which of course struck down the mandatory flag salute at the behest of Jehovah's Witness school children who argued that it violated their religious beliefs. But notably, in contrast with Edwards and Epperson, which come much later, the court did not ground its Barnett holding specifically on the First Amendment's religion clauses, as it plainly could have done, because the Jehovah's Witness school children were raising a specifically religious objection. But the court's rationale for striking that down went way beyond that, and in fact, it didn't invoke a single clause of the First Amendment expressly or singly. It rather just talked about this pervasive and open-ended value of freedom of thought. And to quote the court itself, it was, well, first let me say it was protecting pervasive First Amendment concerns that apply to religion but transcend religion. And the court referred to the sphere of intellect and spirit, which it is the purpose of the First Amendment to reserve from all official control. So in sum, I think it's past due time to revive the broad intellectual freedom rationale from the court's old Barnett case to counter the broad suppressive impact of the new curricular restrictions. Thank you.
Well, I'm not going to talk about the legal reasoning in Edwards against Aguilard. I don't think I could add much to what other speakers have said. And in any case, I don't think that in this area the results of cases are driven primarily by legal reasoning. I think sociological factors are more important here. So instead, I'm going to talk about a different aspect of the case, and that is the illiberalism of Edwards. More specifically, I think the decision and its supporters, and I'll call them the evolution-only party, just as a description, I think that's an accurate description, show all of the signs of something that liberal thinkers have stalwartly and I think properly opposed, something we can call intellectual paternalism. Now, by that, I understand an attitude or a policy based on two assumptions. First, at least in some domains, there's an elite company of people endowed with knowledge and understanding superior to what the general mass of humanity possesses. Second, it's proper for this epistemic elite to determine what less favored humans should read, hear, and learn. As a vivid instance of this position, we might recall the opposition some centuries ago to vernacular translations of the Bible. The opposition contended that there's a group of people, the clergy mainly, who are trained to understand the Bible, and there's another larger group, ordinary or lay people, who are not. At that time, everyone, or at least all reasonable people, as we might put it, knew that the Bible was the Word of God and hence a reliable source of truth. But the Bible is obviously a very complicated work, and if the untutored people were to get hold of it and start reading it on their own, there was every reason to expect all manner of bizarre and ill-conceived and sometimes dangerous opinions to emerge. This was a very plausible view, I think, and it may seem to have been confirmed by what happened when the Bible was made available in everyday working languages. More generally, intellectual paternalism is hardly an implausible position. Its first assumption, namely that some people have more knowledge and understanding than others, is surely true. Nonetheless, liberal thinkers have opposed intellectual paternalism, and in doing so, they've developed a stock of familiar and powerful arguments. Some of these arguments sound in truth. These arguments contend that even if some people are better equipped to form correct judgments than others are, the overall quest for truth will be better served by, to borrow the familiar metaphor, a free marketplace of ideas in which even the less competent are welcome to participate. The classic expressions here are the ones by Milton, Mill, and if we don't read too closely, Holmes. Other arguments emphasize that it's not truth in the abstract that's the good to be pursued, but instead what we might call truth for humans. It isn't just holding correct opinions that matters. The inquiry itself, the struggle to give due respect to opposing views, and the sense that one's beliefs, whether right or wrong, are the result of one's own honest efforts, are important as well. In this vein, Mill famously argued that even false ideas are valuable in enabling a more vivid appreciation of truth. Another revered expression, though not revered by me as it happens, is Kant's famous homily on having the courage to think for yourself rather than simply accepting the judgments even of authorities who are epistemically better situated than you are. When applied to governments and public policies, sometimes this point is put by saying that it's wrong to treat people like children, even people who are, in some respects, like children. So we can ask, how do the familiar liberal arguments about truth and truth for humans apply to the evolution in the schools controversy? Well, if we consider the alignments in Edwards, it would seem to be the court and the evolution-only party who adopt a position of paternalism, and it's their opponents, the Louisiana legislature, the proponents of balanced treatment, or as the slogan goes, teaching the controversy, who take the liberal position. I think that theme was brought out in Patricia Bowers' comments earlier today. The first party believes that there's a community of epistemically gifted people, the scientists, that is determined with sufficient assurance that evolution is the correct theory. So in the interest of having properly educated students, only this view should be taught in the schools. By contrast, the second party argues that it would be good to let students hear opposing views and make up their own minds. Now, even someone who has no reservations at all about evolution could favor the liberal approach here, I think. If the evidence so overwhelmingly confirms evolution, why wouldn't the case for evolution convince most or all students? And wouldn't students be better off for having earned their way to the correct view by confronting opposing but incorrect opinions? In this vein, Joseph Vining, no critic of evolution so far as I can tell, comments on the censorious quality of the campaign to exclude creationism or intelligent design from the schools. Strange, Vining comments, this struggle over the minds of young children. One might think that the theory of evolution, appealing, simple, fertile, fascinating, like a beautiful equation in mathematics, could fend for itself when presented to curious young minds. So why is the evolution-only party so insistent that only evolution be taught? At least part of the answer, it seems to me, is that they believe that if presented with both views, many students will choose the wrong one. And this may be true. But conspicuously absent here are all of the standard liberal themes about the marketplace of ideas, the value even of false ideas, and the importance of forming one's own opinion. Here, though, I need to notice an obvious objection. I may seem to have forgotten that we're talking about children and about schools. The liberal opposition to paternalism presupposes adults. It isn't wrong to treat children like children. And not every place is a marketplace of ideas. Schools can't teach everything. So in schools, it's both necessary and proper that the relevant authorities make judgments about what should and shouldn't be taught. And I'm happy to concede all of this. Schools are not unrestricted marketplaces of ideas, and paternalism that might be inappropriate with respect even to intellectually mature adults may be necessary with respect to actual chronological children. So then why would liberal opposition to paternalism have any relevance at all in this context? I would answer that question with another one. Given that judgments have to be made about what should be taught in public schools, who gets to make those judgments? The answer to that question is complicated, no doubt, but we might say loosely that normally such judgments are made by the community or by the people. Individual teachers make some judgments, but they're subject to direction from higher institutional authorities, such as school boards, which are elected, and on a few matters, legislatures, which are also elected, or even the general electorate may enter into such decisions. All of these people are participants in the marketplace of ideas. In this way, public education might be said to conform generally to liberal commitments at the wholesale level, even if it's not especially liberal at the retail level, so to speak. And this is where the evolution decisions, most obviously Edwards, depart from the normal liberal practice in a paternalistic direction. That's because in these cases, the courts have not permitted the people or the marketplace to make the curricular judgments. Instead, the justices, taking their guidance from the scientific establishment, have stepped in to overrule democratic decisions regarding curriculum. In this vein, in an essay called Why Creationism Should Not Be Taught in the Public Schools, the philosopher Robert Pennock contends that, quote, "It is not relevant that a large number of Americans don't believe that evolution occurred. It does not matter what the figures are, because matters of empirical fact are not appropriately decided by majority rule." Now, this is a slippery assertion, I think. I take it that nobody believes that matters of empirical fact are determined by majority rule. Whether the moon is in fact made of cheese isn't up to a majority vote. Pennock trades on that truism. But it's a different question where there is disagreement about what the empirical facts are, or more accurately, about what theories the empirical facts best support. The people should have an ultimately decisive role in deciding what the public schools should teach. In rejecting such a role, Edwards and its supporters adopt a stance of paternalism. They take the decision away from the people because they don't trust the people to make the correct judgment. In this respect, we might say they treat adults like children. I'm not entirely happy with this statement of my concern, though, so I want to try to refine it a bit. So let me start with Mill's well-known argument that censorship of ideas is objectionable because it assumes infallibility on the part of the censor. This argument has always struck me as not quite right. I don't think most censors either claim or need to claim infallibility exactly. All they need to claim is that they're better equipped to know the truth than the non-elites are, so that the non-elites will do better, epistemically speaking, if they're subjected to the enlightened guidance of the elites than if they're left to fend for themselves. Still, Mill's argument about infallibilism seems to have resonated. He seems to be onto something. So let me try to put the point in a slightly different way. It may be that everyone who believes an idea believes that this idea is true, or if you prefer, rationally warranted, or something of that sort, and that contrary ideas are false. That's what it means to believe something. But some people exude an attitude that goes beyond mere belief. They may not claim infallibility exactly. They might even get indignant if someone accused them of that. And yet, it seems to them that the truth in some domain is so plain and demonstrable that the distinction between what I believe and the truth seems almost to disappear. And because the truth seems so plain, it's hard to accept that any informed person could, in good faith, disagree. So if some people do purport to disagree, it seems to follow either that these disagreeers are cognitively impaired or that they're acting in bad faith. Either way, the disagreeable people are not worthy of respect, not even of the respect we give to people who are, let's say, honestly and legitimately mistaken. Let's call this sort of belief hyperbelief, and let's call the corresponding paternalism hyperpaternalism. Liberals have typically viewed hyperpaternalism as especially objectionable, and rightly so, I think. For one thing, if connected to political power, it's apt to be oppressive. But in addition, hyperbelief is, I won't say epistemically culpable, though it may be that, but epistemically perilous, for two closely related reasons. First, because hyperbelievers regard those who disagree with them as either cognitively impaired or in bad faith, they're unlikely to make the effort to understand criticisms or opposing views accurately. Second, in their extreme self-confidence, hyperbelievers are likely to become complacent. Complacent not so much, or not necessarily at least, in the practice of their epistemic approach, but instead about their approach. They may take pretty much for granted the potentially contestable presuppositions of the epistemic methods on which their self-confidence is founded. Liberals have often accused religious people of these sorts of deficiencies, and the accusations have often been warranted. The persecution of religious heretics was typically based on the premise that the heretics could not really sincerely believe the patently erroneous ideas they purported to espouse. So the heretics must be acting in bad faith, or they might be deranged. But if they persisted in their heresies even after their errors had been clearly explained to them, well, they deserved what they got. But hyperbelief, and hence hyperpaternalism, are not exclusively connected to religion. Although I admittedly don't spend a lot of time engaging with the evolution controversy, I do occasionally read an essay by the late Stephen Jay Gould or the like, and I'm almost invariably struck by the marks of hyperbelief in this material. Gould and company exude certainty that no intelligent and informed person could honestly disagree with their overall position. Consequently, proponents of creationism are virtually always treated as cognitively deficient or dishonest or both, and hence is worthy mainly of ridicule or contempt. In an essay on Edwards, Gould asserts that all scientists, without exception, accept evolution and reject creationism. People with apparent scientific training making ostensibly scientific arguments are thereby magisterially excommunicated from the congregation of science. In addition, Gould and company typically seem quite certain that they know the real beliefs and motives of the creationists, and that these are different and less admirable than their publicly stated reasons. This sort of attitude is obviously not conducive to mutual respect or dialogue, but is it epistemically perilous in the ways I've mentioned? Here again, my own experience and reading are too limited to support any confident judgment, so I'll only say that it's not obvious to me, anyway, that the evolution-only party is immune to these dangers. One danger, again, is that hyper-believers, because they can't or won't respect their opponents, will be unable to understand or accurately state what their opponents' views actually are. In the evolution-only literature that I occasionally read, it's common to see the creationist or intelligent design position described in terms that, even given my limited experience in the field, I know to be inaccurate. Thus, in his essay on Edwards, Gould described the Louisiana Law as an attempt, quote, to inject Genesis literalism into science classrooms. Now, of course, Gould may have supposed, in fact, he quite clearly did suppose, that he knew what was really in the minds of the law supporters. What they would really like to do if they had their druthers is teach Genesis literalism. Lacking Gould's cognitive powers, I can't say. But even if Gould was right about what creationists would ideally prefer, as a description of what the law actually mandated, I submit that this is a grotesque distortion. Ironically, in the same essay, Gould repeatedly complained that Justice Scalia and others had misdescribed the scientific enterprise, but he seems to have felt no scruples at all about offering crude and demeaning caricatures of his opponent's project. Evidently, they didn't merit accurate and respectful treatment. The other danger I've mentioned is that hyperbelief can cause the believers to become complacent about their own presuppositions and potentially contestable assumptions. Does this possibility apply to the evolution-only party? Once again, I would need a lot more experience in the field to form any confident judgment, but my more limited experience leads me to suppose that the concern might apply here. I'll mention in closing just two instances. I recall a regrettably brief conversation a few years ago with a lawyer who had helped write the amicus brief in Edwards for the Nobel laureates. That must have been an interesting experience, I said, working with such brilliant people. I don't know how many he actually worked with, but some evidently. And I recall his response close to word for word. Yes, they are brilliant, he said. And then, after a thoughtful pause, added, and yet remarkably innocent of the presuppositions of their own discipline. Now, he was on his way to some engagement, so I didn't have a chance to ask what he meant by this, but the comment brought to mind an incident in which, after a public lecture, in which I had mentioned the evolution in the schools controversy in passing as a standard instance of the difficulty of achieving a truly neutral curriculum, I was accosted by a scientist who, for some reason, found this observation offensive. He proceeded to instruct me for over an hour about how science works. It was, as you might imagine, a very idealized depiction. I might say exquisitely idealized, possibly exceeding any depiction of the church ever given by the most devout cleric. And he urged me to read Stephen Jay Gould, who I take it was an evolution author accessible even to lawyers. I replied that I had read some Gould, and I asked what he thought of Thomas Kuhn. He hadn't heard of Kuhn. I'm pretty sure that not all scientists are this naive and self-satisfied, or this hyper in their believing. I certainly hope not. But I do think that the decisions in cases like Edwards and the typical supporting discussions that surround these decisions show marks of hyper-paternalism. And so I think that it's not so much the substantive results in these cases as their illiberalism that ought to be troublesome, even for people, and I consider myself one of them, who have no objection to evolution and who have a good deal of confidence in and appreciation for science.
We are a little short of time, but I thought we would have maybe each person ask one question of another panelist at their choice, and then we'll turn to Q&A. And let's do it in reverse order. So, Steve, if you want to turn to...
Oh, okay. I would actually like to ask Nadine a question that was occurring to me as you were talking, because I was quite sympathetic to a lot of what you said, but I had the impression that you were going to be coming down. You pretty much agreed with Eugenie on including, for example, on the recent academic freedom proposals and so forth, and yet everything you said seemed to go the other way on those. You know, it seemed like it would lead to a different conclusion on those questions. So I just wondered if you...
No, I mean, I haven't delved into the legislative history there. I would defer to Jeannie. But my argument is that if the purpose of those laws is to suppress the teaching of any topic specifically because of disagreement, ideological disagreement, even if it's not religious disagreement, that would make the law violate the First Amendment. So if, for example, the reason that there is, and the law does it very subtly, right? So I'm oversimplifying. Assume that the reason that the law was written to say that teachers may teach alternative theories about global warming or however it's worded. If the purpose for doing that is to suppress teaching about global warming or to skew it because of disagreement, not because of rejection of the science, not because of a belief that is educationally unsuitable, then I think that should be equally challengeable under the First Amendment, even if it wasn't a specifically religious purpose.
Nadine?
My question, I guess, if I have to choose, is for Kent. I was fascinated with your list of limits on science, and I was wondering if that were those created from your own knowledge of science, your reading in the philosophy of science, or where do those? Because I was surprised at some of them, quite frankly. I mean, you said you had thought about it a lot.
This is a very nice way of putting a question, which seems to be you really haven't thought about it if you could say these things.
This is more from the earlier panel. From the earlier panel, I learned that there is this whole group of people who spend full time studying and writing about these very questions.
Okay, so I guess what I'd say is that
And I'd be curious to hear if they agree with what you said.
I certainly did some reading. There was a book on sort of the evolution controversy, a long book with essays on both sides, and I read through that and read some other things. And I guess partly when I say it can't tell us anything about why there's anything, I mean, that's just what I think. I mean, it just seems to me it's logically true that that's not a science. So, I mean, so it's kind of a mix here of things that I think are self-evidently true on thinking about them, plus things that are, you know, based on readings that are relevant.
Kent, your turn.
Okay. Yeah. She would, yeah.
Oh, we
Yes.
talked.
Yes.
Oh, gosh.
So Nadine, so I'm going to respond, I'm going to
Yeah.
ask you a question.
Sure.
So, but I'm going to put it as a comment that it's a question. I think if this was as broad as I thought it sounded like it might be, it seemed to me it was very questionable unless there was at least some compelling interest that would be on the other side. Because suppose that what you said is passed a rule that no school teacher can teach that the white race is actually superior to all other races. That is an ideology. But can you prohibit that from being taught in public schools? I'd say yes, you
Yeah,
have to.
but that's-
Or you know, or suicide's actually desirable for young people if they become a little unhappy.
Oh,
Or you know, use of heroin's actually a good idea. Or you know, well, really on examination, the Holocaust was justified. I mean, I think there have to be some things that you can just bar school teachers from saying are right.
I think, just off the top of my head, the one about heroin, I would put in a completely different category, because I think there you could have scientific evidence about the health impacts, pro and con. But on the other two, you've really put your finger on what is the central, most difficult paradox about this dual role of the public schools, which has bedeviled, if I can use that word, the Supreme Court, because all of its decisions acknowledge, on the one hand, it really does serve an inculcative function, and there are certain values that are critical to and widely shared, or should be widely shared, among our democracy. That, and one of my favorites, which comes from West Virginia Board of Education versus Barnett, the court actually says one of the values that should be inculcated in the public schools is support of civil liberties. Yeah, well, yeah, I'm not going to disagree with that. And you're talking about basic ideas of equality, tolerance. I recognize that this becomes very debatable, because it could be that it's the paternalistic liberal elite who accepts these values. I know very well from other controversies in the public schools that we haven't talked about, that there are many religious people who strongly believe that tolerance, for example, and equality is a value that contradicts their own religious beliefs. And you know, I've actually written a very long article about all of this, and my solution is that when you're talking about really shared values, you don't take them out of the curriculum, but you do allow an exemption from that particular piece of the curriculum for the religiously objecting students. And there I'm in a minority among certainly ACLU leaders in supporting that more liberal accommodationist approach.
But just so that you could forbid the school teacher from teaching this is correct.
In terms of racial superiority,
Yes,
absolutely.
yeah,
The
okay.
Holocaust. Did you say something about the Holocaust didn't happen? That would be just
No,
bad
not that it
history.
didn't happen.
But
It
that was a
actually
good
was
thing.
justified.
Yeah.
I don't know where to begin. I'm sure we'll have, you know, more discussion from the audience as well, but let me pick on Steve. Setting aside the value-laden terms, evolution-only, paternalistic elites and things like that, let me give you a paternalistic possibility here. I'm a thoracic surgeon, but I'm a follower of Rudolf Steiner, who is an anthroposophist. And now they don't believe that the heart is a pump. Now, Dr. Jones over there is I made him up. I don't know that there really is a Dr. Jones. Dr. Jones, you're looking like, you know, she's going to do something. Dr. Jones over here has been trained with modern medicine, and he has a more, you know, he has a standard medicine only view of the heart. Lie down and take off your shirt. Which one of us do you want operating on you? chances are you're going to go with him, but, because there is such a thing as expertise.
You have a rather I take it, in your hypothesis, you have a very peculiar hypothetical.
That the heart does not push blood around the, you probably don't want me to be your thoracic
I'll go with
surgeon.
Jones, I
You'll
think,
go with
yes.
Dr. Jones. So everybody agrees here, I'm sure, that there is a role for this paternalistic expertise. There are times when you really want to go with expertise.
I think we are all the time making
call this
decisions
paternalistic.
for ourselves about. Yeah.
So, when it comes to what do you teach a 10th grader, as you pointed out very wisely, I think, the school is not an open public forum. You have to make decisions about curriculum. You have to decide what to leave out, what to leave in. It would be lovely if we could teach everything we can. So we do have a curriculum. And I was also very interested in your idea of who makes these decisions. And it was really wonderful when I read Ed's wonderful book on the Scopes trial. I was struck by William Jennings Bryan position that the community should make these decisions, that they should not leave things up to experts. Experts, scientists, expert teachers should not be determining the curriculum. We should vote on things. And of course, we have our beloved chairman of the Texas Board of Education, Don McElroy. Someone's got to stand up to experts. So we certainly have lots of echoes of that today. But the question is, do we want to have students in Alabama learning that the South won the Civil War and students every place else learning that the North won the Civil War? Do we want, that's actually not an opinion, okay? Whether the earth goes around the sun or the sun goes around the earth is not an opinion. Whether living things have common ancestors is really not an opinion. There are lots of things about which we have opinions, and I think many of your comments really apply more to matters of opinion than to matters, as Rob Pennock would say, of empirical knowledge. So the question is, how far do we want to extend this idea of honoring opinion when there actually is expertise involved, when the heart really does pump blood, and that's what kids should be learning?
Well, wow, there were a number of sort of distinctions assumed in your question that take me a long time, I'm afraid, to try and break all
if I
down.
misstated your position.
Maybe I should just take your one instance of, do we want schools in the South to teach who won the Civil War, the South won the Civil War? So, I mean, there are all kinds of questions about which people may have different. Somebody's going to be deciding those questions, I think, right? Yep. I don't think that one, I think even the Supreme Court would not purport to say, we're going to sit in judgment on all of these other sorts of issues to make sure that schools in the South don't teach things that
it's not illegal to teach bad history.
So at some point, for better or worse, I think we are left with making human judgments in the best ways that we have, given the human beings who are running legislatures and school systems and so forth, and experts or others of us who don't agree with the majorities in some cases may find that frustrating, but it's not clear that there's a better alternative, I would say. So as far as the paternalism part, I should just say, I think that maybe that's a pejorative term, but it is a very standard term for a certain kind of position, I think, and liberals use it all the time, I think properly enough, to describe a certain kind of position. So maybe I could come up with somehow a new term to describe that familiar position, but I don't think that there'd be too much point in doing that. I didn't mean to be trying to, and with the evolution only part, I needed a brief label for the position for people who think, as I take it you do, that in the science classes only evolution should be taught and none of these other things should be taught. So I don't really see that was a loaded term.
Only is the position that we would take. Evolution only is what the intelligent design people use. That's their phrase. And they use it as a pejorative, of course.
So Nadine, I want to ask you a question. So there are, by my mental guess, about 40 million students who are essentially captive audiences to the public schools. The taxpayers of the country contribute probably about $400 billion a year to teaching this captive audience. Somebody's got to decide what to teach them. Somebody's got to decide whether to teach them racism is good or racism is bad. Sexism is good, sexism is bad. Tolerance for homosexuality is good or bad. Protecting endangered species is good, or maybe we should eat them all. Infanticide is good. Ancient Romans believed that. Infanticide is bad. All of these decisions have to be made by somebody. Now, The Supreme Court's view, as best I can tell right now, is that the representatives of those who pay are the ones who are entitled to make the decision, setting aside the Establishment Clause area where the justices get to make the decision. But everywhere else, representatives of those who pay get to make those decisions. So they're basically the state legislatures, if they wish to, very often under state constitutions, the State Board of Educations. And it will never be the person who happens to be hired by the representatives of the people. So the teacher isn't the one who's entitled to say, well, I have a different view about cruelty to animals. I think it's actually a good idea. I have a different view about heroin. There may be scientific facts about what, in fact, there are scientific facts about the dangers of heroin. There's no scientific fact about whether it's a good thing to use it nonetheless, right? Maybe it's the fun outweighs the danger. So all of these decisions have to be made by somebody. So as I understand your proposal, for a certain class of viewpoints that are seen as intolerant or whatever else, the First Amendment would have this viewpoint-based ban on those viewpoints, or at least it would be okay for state legislatures to ban that. But for other viewpoints, it would be up to the school teacher to make this decision.
No, not to the school teacher.
Well, who decides? Because you say a legislature can't say, we won't teach the idea that infanticide is good. We won't teach the idea that animal cruelty is good.
Let me just say, all that I am doing is taking what the Supreme Court has said in the three cases on point, Edwards, Epperson, and Pico, and extending that.
So in Pico, four justices said one thing, four justices said the opposite.
Okay,
Yeah.
well, except that the four who said the opposite were in some ways closer to my position on curricular issues. But putting that aside, and in every other case that has involved public schools, which include the Barnett case and a number of other cases about religious exercise in the public schools, the Supreme Court has always gone down two tracks. It said, yes, the public schools are there to inculcate shared values, and the shared values are tolerance and equality and respect for individual rights. And we really defer to the discretion of the elected officials or whoever is, you mentioned some of the possibilities who make those decisions. Therefore, courts should rarely intervene, and I can remember the exact phrase. We should intervene only when constitutional rights are clearly and sharply implicated. Is that the exact phrase? So, it's like a double cautionary note, but we do have a responsibility to do it in those cases. And in Pico, the court said, if a reason for making a decision, in that case it was library book removal, is narrow partisan disagreement with the ideas, for example. And I want to use these extreme examples because I do think that, in the vast majority of cases, let's say, the vast sea of gray, the courts are not going to intervene at the behest of a plaintiff who probably is going to be a student or a parent and not a teacher. I don't know that matters. But some cases are so extreme that I think they do warrant intervention beyond the sphere of religion. And so let me make another point. If one accepts that the court was correct in Edwards and Epperson, then I say, why should there be more protection against indoctrination on the basis of a religiously premised disagreement with certain ideas, the theory of evolution? Why is that more protected than depriving students of access to ideas because of a non-religious ideological disagreement? And the court in Pico gave two examples. They said, if a school board, for example, decided to remove all books from the library that were written by Democrats rather than Republicans, because that's their politics, that would be going too far, even though we give this great discretion. The other example is a little bit closer to what Kent raised, and they said, suppose a majority white school board said we're going to remove all library books that were written by African Americans. And my view is those are extreme cases. They have nothing to do with the Establishment Clause, but if something like that were a basis for a curricular decision, it should equally be beyond the First Amendment pale, despite the fact that we give an enormous amount of discretion. So it may be few cases, but it may apply with respect to some of these laws.
So do we have any time for questions from the audience? I think we would have a little, no? Pardon?
The next panel.
So I guess with that I have to thank the fellow panelists.